I first came to know a few DNA exonerees when I was a lawyer in practice. And as a rookie lawyer working on cases in New York City, I worked at a law firm where the partners were Johnny Cochran, Barry Scheck, and Peter Neufeld. Scheck and Neufeld founded the Innocence Project, and a number of the interesting cases that that firm had were wrongful conviction cases where people who were exonerated by DNA evidence were seeking compensation for all of their years behind bars. And so I worked on a few of those people's cases, and I wondered whether what happened to them was unusual, was it typical, were other exonerations like theirs? I worked on cases of people who falsely confessed. I wondered what happened in other cases where people falsely confessed. I wondered, well, what did the habeas courts do? What did the appellate courts do when they confronted the cases of these innocent people without the benefit of DNA testing? So the first study that I did, I looked back at their cases and all the appeals and habeas petitions that they brought to see what claims they brought and how did courts rule on their claims without the benefit of DNA to prove their innocence. And what I found in that first study called Judging Innocence was that many of these people did not try to attack the evidence at their trials, which we now know to have been flawed. And judges often, in their rulings, indicated a firm belief that these people were guilty. After I did that study, though, I was contacted by the National Academy of Sciences, and they wondered what role forensic science played in these people's cases. My response was the only way to find that out would be to look at the actual trial transcripts themselves, because appellate and habeas rulings don't tell you how forensics were used at trial typically. Often they don't discuss the forensics at all. And so I began a project looking back at the trials, just focused on the forensic evidence. And what I found began to disturb me. I saw that in case after case, the forensic analysts were saying things on the stand that were invalid, that were exaggerated. They used unreliable techniques. They used conclusions that were vague or would be confusing to a jury. And having assembled a pretty large body of these old trial transcripts, and having scanned them, I decided I would try to finish the project and obtain trial transcripts for as many of the first 250 DNA exonerees as I could. The goal was to see what patterns are there. Are there patterns in these cases? What went wrong in these 250 DNA exonerations? Are these exonerations aberrations, the product of bad faith acts by cops who are out to get someone or frame someone? If that was the case, then these cases would be unusual, but they shouldn't bother us too much because most law enforcement, most prosecutors have good intentions. What I found, though, was that the errors that repeated over and over again across these 250 cases were the product not of bad apples, but of bad barrels, of bad criminal procedure practices, systemic practices that allowed well-intentioned actors to contribute to convicting innocent people. And what's so troubling about that is it suggests that there may be many, many more cases like this that have never come to light because DNA testing can only be done in a small minority of criminal cases. DNA tests have only been used in this very narrow band of serious rape cases, rapes by strangers from the 1980s before DNA testing was common. DNA testing can't be used in the vast majority of criminal cases, but in the vast majority of criminal cases you have the same evidence. You have the same forensics. You have eyewitness identifications. You have confessions. You have informants. And so what I saw in these 250 cases gave me grave concerns about the accuracy of other criminal cases where DNA testing can't give us the answers.